Hello. Can the court hear me? Are we ready?
Yes, I can hear you.
His accusation number is 23 CR. He's charged with harassing communications. The alleged incident date for his case is 7/26/2023. Today, during his first appearance bond hearing, there was some allegations or information about Miss juvenile history record related to sexual charges that he was charged with, several charges that he was charged with. During this recitation of these charges, the court was in a live proceeding that was being broadcasted publicly. Additionally, the paperwork that was received for the charge this morning for harassing communications, as well as the pretrial report that the public defenders received, did not have any information that would possibly relate to, and that there were any sexual juvenile charges that would be spoken of publicly during his live hearing. As a result, we understand that this is a live hearing. It is equitable to people being present in court, and that matter has came and gone. We did object at some point, and the court did place us into a breakout room to further discuss the matter, which we appreciated from the court. But the amount of information that was put out live on public broadcast is now, once this session is completed, able to be posted and saved on YouTube and accessible to the public, thousands and millions of people. That is no longer equal to people appearing in court. Juvenile records are not accessible to the public. And so for someone to be able to pull up this YouTube live public hearing and to be able to hear the juvenile record of Mr. is a violation of his rights, and they should not have access to that. It will not only affect his possible education and schooling or college or anything else where he goes to apply for a job and his name is pulled up, and then they can pull up this hearing, and then they can see juvenile records that they do not have access to for charges they do not have access to. Furthermore, for safety purposes, anybody on the road publicly, anybody who has any feelings towards someone who is accused of these types of charges, who wishes to do harm to people for these types of charges, because this is no longer will be live, this will be saved for the public, can access this recording and see the charges that they normally would not have access to. And so we are saying that the saved recording and the public posting of this recording puts the information about Mr. juvenile history in a different posture than it would be if it was just live. And now we are posting information to the public that the public is not entitled to see or have access to. And so we are requesting that the court, for that period of time in which the ASG went through the specific sexual history related to the juvenile record of Mr. silences that part of the hearing so that it is not broadcasted publicly indefinitely to thousands or possibly millions of future viewers who has access to these recordings. We do understand that the Constitution allows for public hearings, and we do believe that the live proceeding of these hearings have done that, but we do believe that public hearings and saved hearings posted on the internet are not the same and equal nature. And so we are asking for the court to take that curative nature of silencing that portion of this hearing before this is publicly posted to the YouTube page of the Fulton County Department or whichever page that it is posted on.
And Your Honor, if I could
All
respond,
right.
please.
State.
First, I'd like to point out, well, first I'm asking that you deny the request, and these are the reasons why. First off, the defendant did not waive his presence. We do not have a waiver on file, so it's inappropriate to even have another hearing about this without him being present. Second off, the objection is not timely. Third off, under OCGA 15-11-703, juvenile records are admissible at bond hearings. This is a bond hearing, and all hearings in Fulton County are open to the public. And lastly, it's not his juvenile record that was put on the record. He's charged with statutory rape as an adult. Let's be very clear. That's not juvenile record. He is 18 years old. There was no juvenile record put on the record. He's charged as an adult. So that defeats counsel's whole argument. Oh, this is a juvenile record and shouldn't be able to be broadcasted. Well, newsflash, it's not a juvenile record. He's charged with statutory rape as an adult. He's 18 years old. And lastly, there's no legal basis. So for all those reasons, I'm asking the court to deny the request.
And I just want to be clear for the record that I thought I heard the ASG said juvenile record. And so that's a correction if I'm wrong. I thought that's what I heard.
He went to felony first appearance today. And as of today, he's 18 years old.
I'm just saying when the charges were read, I thought what I heard from the ASG was she said that these were juvenile charges.
I'm not showing a juvenile record. I'm showing statutory.
My argument is the same. I'm just saying that's the only reason I said juvenile.
Well, that was the whole basis of your argument, that juvenile records are not accessible to the public. It's not a juvenile record. So the argument is not the same. Well, and it's not founded.
Yes, Your Honor. This incident was alleged to have occurred on July 26th to July 29th of 2023. The victim, Brian, Trian, began receiving messages through Facebook and comments on personal posts by the defendant on 7/26/23. The victim advised him that same day he wanted all communication to cease. Since then, the victim has received multiple messages harassing him, rating him, and calling him the N-word. The defendant stated to him, "You effed up now, it's my turn," which came after he was already issued a criminal trespass warning from the victim's residence. The end of the messages stated, your curse word, another curse word is all talk. You ain't never gonna touch me because you know I would F your another curse word up. The victim stated that he felt harassed and tormented by the defendant's continued communication. After asking him to cease all communication, he stated that he is frightened the defendant will escalate his behavior and is fearful he will come to his property to damage his residence or cars outside. He thinks that the intimidation is because he's in a relationship. The defendant is in a relationship with his juvenile daughter, and the defendant was advised that he couldn't see the daughter any longer. It is of note that this defendant has numerous sexual related cases pertaining to this victim's child, including a case for sexual intercourse with a minor, employing a minor to engage in performing sexual explicit contact for a visual medium, electronic furnishing, obscene material to minors, obscene telephone contact with the minor, enticing a child for indecent purposes, aggravated child molestation.
Objection, Your Honor. Objection. We would ask the waiving of the sounding of those types of charges in an open live hearing, or that we go into a breakout room for the prosecution to mention that.
And Your Honor, my client is innocent, presumed to be innocent. I don't think it is appropriate for those charges to be brought up.
Okay, I understand.
Prejudicial.
This is the first arrest in Georgia or first adult arrest? From what pretrial gathers?
Adult arrest. He's only 18 years old. He just became 18.
Just turned 18.
Yes, Your Honor.
And
well,
so
his
that means
juvenile record is right. His juvenile record is able to be disclosed, but when we have some of the other sensitive type charges, we do like to only sound those in a breakout.
Your Honor,
for the safety of the defendant.
Your Honor, I understand cutting off the live stream and the YouTube, but I don't think there's any actual basis for the objection. Those are charges that have been laid against him. I'm not even going into any of the factual basis, which I still don't think would give rise to an actual objection. These are the charges that are against him. I'm sure whoever wanted to look up his charges could easily find these charges the same way they could find the charges that are present before this court. I was pretty much done, but the court has already heard that there's numerous charges against this defendant for these offenses stemming from the relationship he had with the minor child. And so I don't really have anything else to say about that. And so I don't think
okay. Then let me ask you this. What are the charges before the court today? Because I only have one count of harassing communication.
Yes, I think
yes,
that's the only one that we should be talking about, Your Honor.
Your Honor, I would just ask that I be given a chance to finish the portion that I wanted to finish before the public defenders. It seems that there's two public defenders before they both have a chance to speak, because I haven't finished going over the recitation of the facts and or my bond recommendation. And I would just ask to be able to finish before both the PDs have a chance to speak.
Well, now, either way, this is a hearing that's going to be published on
It's an open
YouTube.
hearing, correct.
And we do not believe, based on the nature of the charges, juvenile record or not, that this is something that the public should have access to permanently, to go back and to be able to review for someone who is accused and charged of this. This is outside the realm of
quite frankly,
public.
that's your opinion. Your opinion is not
And
based
I'm just
on the law.
making the record. I'm just making the
Your
record.
opinion is not based on law.
I'm just making the record. It is outside of the realm and access of public access to hearings. Now we are publicly posting records on a virtual forum and submitting them to the internet indefinitely to be viewed by anyone who wants to view the case. And so if he moves forward and his case is adjudicated as a first offender, and this is taken off of his record, and the public is not supposed to have access to that, he's supposed to be able to say he's never been convicted of a crime.
Again,
and this
you're
is
wrong, because the postings
and
only
this
last for
is
2 weeks.
publicly posted,
For 2
then
weeks.
the public will have access to what is no longer supposed to be a
Not after 2 weeks,
conviction
they will
or
not.
something that is viewable on
But
his
that
record.
would be the case for anyone in court. And when they're sentenced to first offender, their history is already read, it's already there. And then they what happens is really, all of that same information is discussed and read in court. Then the court decides whether to accept their first offender plea. They do, but then the court reporter doesn't say that I'm going to X all that out because of first offender. It's just when his criminal history is ran, when he later goes for a job after he's completed first offender, they won't be able to see it. But someone could be sitting in the courtroom, as Mr. Walker stated, and hear all of that prior to the court ruling on whether he gets first offender.
And Your Honor, we acknowledge that. We are saying the
And they could
virtual
post and do the same thing.
the virtual nature and posting online of this is what we are saying makes the difference between somebody sitting in court, hearing it live and knowing that, versus it being published online indefinitely, where someone has access to, where the entire public has access to indefinitely. We are saying that is the difference between people who can walk in court or look at this live. Everyone has heard it live, but when you post it online and you make it permanent online, then it turns into it's a different question and it's a different posture. And that is our only argument.
It's the responsibility of the clerk to keep
I do understand you.
You can walk into the clerk's
but I
office and request
believe it sounds like there was a mistake made by saying it was his juvenile history when it wasn't. It was his felony first appearance information. Is that correct, Mr. Walker?
That's correct.
That's correct. And we acknowledge that mistake, Your Honor. Again, I said I thought what I heard from the ASG was that it was juvenile. So that mistake is acknowledged on my behalf.
So if it's not his juvenile history, but it's his felony history,
then it is then it
Then
is
what?
the posting that we are objecting to on YouTube, this being posted virtually online indefinitely is the part that we are objecting to, because we understand that it's not a juvenile record, so people can, it's the access. We are saying that because it's being posted and it's going to be accessible, it is outside the realm of a live public hearing where people just can go and sit and listen to something. Now that it's being published online, if he has first offender, people can go back into this saved online history and pull up this video and see that he was charged with these charges.
But
And
won't this happen on any case? And I don't mean to cut you off to be, I mean, I'm a former prosecutor myself, and I've never heard anyone make that argument, because those things are always stated in open court, and people can bring their phones and still record. We don't know because they don't take the phones from him. And I don't know that that part of your argument to me makes sense, that if he gets first offender later, it will be out there in the universe. Well, Michael, Mr. Jordan?
I mean, I don't understand what the whole argument is.
The issue
we are arguing a procedural argument today, I don't even think that's for today's count. See, if you're talking about first offender, somebody getting first offender later on down the line, and us removing something from off a YouTube live stream, because it's right now, it's already out on YouTube.
The first
offender later.
The first offender is an example. What we are saying is this should not be published and saved online. This is not the same thing as somebody coming and sitting in court.
So then that's not an argument for today. That sounds like something.
That is an argument for today, because once the court is over, this is going to be published online.
It's already being published online.
It's already,
no, it's live,
right?
It's live right now because we're still in court, but it's going to be actually saved.
So what is your argument today to say that you don't want to save online today?
We are saying that we do not want this published online.
Today.
Is what we're saying. We don't want this
So that is the judge. Judge Macy didn't make that decision. That decision was made by our court administration. So that's what I'm saying to you. If you don't want any of these SEA hearings being broadcasted online and saved online, if you don't want any of the SAP hearings being broadcast and saved online, that is something you need to take up with administration.
We are just putting our
in the form of a motion for this particular court, but this. And actually, I don't know that we would have the ability to delete it or take it down later, I guess, outside of a court order, because it was live streamed.
We're just
not saved, recorded, and uploaded for later.
But it's going to be saved. We're just putting our objection that we have objected to this being posted and saved online and accessed for later. We could not object to it being live streamed. That's already done. We're just saying for it to be posted, we are objecting to that portion of it being posted online for everyone to see later on. That is all we're objecting to.
Okay, so we take this down and his felony first appearance is still online on YouTube. So then what? They're going to go watch that.
You said what?
I'm not agreeing, but you want us to take this down, but then the felony first appearance is still on YouTube.
Yeah, so it's going to be heard over there.
We're just objecting for our client. We're not agreeing that it should be. This shouldn't be streamed online because the courts are open. We're just objecting per client. This is the client for today who's dealing with this matter, who information was given out during this hearing. So for today, we're saying that portion of this video, we are objecting to that sound portion being.
But Michael, don't you have to go back? You know, when you go back to look at court from last week or the week before, do you have the ability to not post that, or does it go automatically?
So
because it was recorded.
It saves automatically, but as the managers of the account, we can not post anything on YouTube that we don't want people to be. Like I could go on there right now as soon as this thing save and not allow access to the video.
But I do believe it would have to be in the form of a motion to be reviewed. I don't know that I would just summarily do it, because I don't see it different from any of the other trillions of cases that I've heard since 2020, since being sworn in and starting.
And Your Honor, we
hearing.
understand that
We've
can
had
prepare
similar issues and matters and cases. I mean, you know, Mr. Walker's aware as well, and I think we would set a terrible precedent if we, based on your oral motion, did this. It may be something that needs to be heard and addressed in a written motion. I'd like to see some statutes and law for it. You know, I don't know, it sounds like it's a round table for the, you know, the solicitor and the clerk and everybody else and the chief judge, because I don't know. I hear you. I understand your concern, but I think every other defendant in similar situations would have the same concern. And I don't know how you go back and do that. If he gets first offender on it, again, when he goes to apply for jobs in colleges and he completes his first offender, it won't be discoverable, and it won't be brought up in the background check. Isn't that right, Mr. Walker?
Well,
certain
Google
employers,
lives forever,
depending
so
on their
always
ability of
find-
what kind of background check they're
You
doing.
can correct, and you can always find criminal records online. So even if you take first offender, you can Google someone's name and see what they've been charged with. So I'm not sure.
And we can prepare, we understand that, Judge. We can prepare a written motion, and I'll have that conversation with my supervisor. I had it very briefly with him, and I do believe you are right as far as we need to take this up with, it's gonna be a round table type of thing. But we will look into preparing that motion. But I do want to say this last very thing, and according to what you just said.
Is your supervisor Mr. Howard? Or
Mr.
someone else?
Howard, yes, Your Honor,
Okay.
and Miss Jinks. And it may not be it shouldn't be pull upable, their record, if it's first offender. But if these things are continue to be published online the way they are, the same thing that's not supposed to be pull up, they can pull up during these video hearings or these virtual hearings online. And that's what we're saying, that's going to be an issue. And so, but we will file a motion if after I talk to my supervisor, if they think that that is the best course of action. We just wanted to make a note for the record.
Just to be clear,
Okay.
that's not the way first offender works. Even if you get first offender and you complete it successfully, you still have to file an additional motion to have the public record sealed.
Or
So-
you can have it sealed at the
Right,
time
no,
of the
but
plea.
even if you get first offender, you still have to file that motion to have your record sealed. So if someone goes through the process of getting first offender and then files a motion to have it sealed, then maybe you would have a conversation. But right now, no one's taking a plea to first offender. A motion has not been filed to seal the public record. And until then, I think we're talking about the cost of tea in China.
You would
I'm
think
trying
that,
to
you know,
hear
it's not-
and
it
find
wouldn't
out if
affect
there's
you.
any prejudice
So,
or
no,
harm
that's in the
that
crime.
is coming to the defendant. And what is the prejudice or harm to this defendant versus the trillions of others? What is different about this one versus
We
any of
don't
the other
believe there's
similar
a difference,
cases that
Your
we've
Honor.
had?
We don't believe
that
there
we've
is a difference.
discussed in
We
the
just
past.
think that we haven't been addressing it, and I think we're gonna address it now.
That's
But we will
okay.
have that conversation with our
Okay.
supervisors.
Yes.
Okay.
Thank
Okay.
you.
All right. You're welcome. Thank you.
Okay, now that we have gotten all of that out, can we go over the calendar?
Yes.
Yes, ma'am.